Yes. WPC 71 of 2024. Having considered the submissions made by the learned counsels for both the parties, this court finds it appropriate to dismiss the instant writ petition on finding no grounds to interfere with the promotion order issued by the state respondents.
Obliged.
Yes.
My Lord, I would like to seek your Lordship indulgence in making a mention of Part 2, item number 3. This matter may be taken up this coming Thursday, my Lord. I have taken the consent of the other party.
Okay, so both the parties be present on Thursday.
My Lord. Obliged.
Your Lordship, may I make a mention for unlisted item? I have filed one writ petition last Friday, and it may be taken up tomorrow, my Lord.
What is the urgency?
There is urgency arises that, Your Lordship, this is, the petitioners are the degree holders, and they are not allowed to participate in the recruitment process for motor vehicle inspector under Transport Department. Because that recruitment rules says that, it merely says that it is for the diploma course holder. But there is no bar for the higher degree holder, that is bachelor's degree,
So
to
are they
participate.
also having the diploma?
Diploma, no, my lord. But because, Your Lordship, there is only one judgment of this honorable court. This is a covered
and
matter.
also the apex court, their judgments
Exact-
higher.
exactly.
But the requisite qualification, whatever that basic should be there.
Yes,
that
they are.
have.
No, they are not. They do not have this 3 years diploma course, but they are degree holders. They are in a higher. They are higher education.
We'll have to see.
Yes, ma'am.
Okay.
I seek your Lordship indulgence in mentioning item number 4 and 7, your Lordship, Part 2.
Batu.
Your Lordship, if this matter may be listed after 2 weeks,
Why?
the council, the government advocate who handled this matter is on leave, your Lordship.
Who was on leave? Caroline Kalan.
Miss
was-
Mary.
Yes,
Miss Mary and Miss Caroline is on leave.
Okay. So have you taken the consent? You take the consent first, otherwise someone will have to handle.
Yes, your Lordship.
Come back later.
Item 2,
Lordship, I seek your
learned
indulgence
advocate
in-
for the respondent. I mean, I had a talk with him, I probably is there. So he was seeking adjournment on the ground that they have not yet filed their affidavit in opposition.
Which item?
Item 2, my lords.
Okay, let them call out the matter. Let them make mention first. Yes.
Lordship, I seek your indulgence in mentioning item number 6, part 2.
Yes.
May the matter be taken up on Friday.
Consent of the, okay, both the parties on Friday. Yes.
Yes, another quick mention, Your Lordship, Part 2, item number 8. Lordship, I am for the appellant, the leading counsel, Your Lordship, Mrs. Dinari Tezel. She has recently lost her mother just last week. So she's gone to see her and will not be able to come back for a couple of days.
Okay. Mention is made on behalf of Ms. Dinari Tiazo, learned counsel for the appellant, for adjournment of the matter due to bereavement in the family. In view of the above, list after 2 weeks.
Yes, Your Lordship.
2 weeks.
May I seek your lordship indulge in mentioning part 2, hearing item number 2. With the consent of the other party, my lord, if the matter may be listed after 2 weeks.
You are on
My
behalf
lord,
of?
my lord,
Mr. Evlal Engliana.
my lord, I am appearing for the petitioner, my lord. They are seeking 2 weeks time for filing their affidavit in opposition. My lord,
Which
may I
one?
request that the matter be
Hearing
taken out
matter?
to
No,
9?
hearing. This is hearing matter.
No, item 2, my lord.
No, let them call the matter. Now, they are
He has
making
mentioned
mention
item 2,
for
I guess.
those item 2 in what? Part 2.
No, I heard that she mentioned item 2. That is why.
Part two. Hearing matters for this week. Let's finish that first. Okay. Then the court master will call out the item. Your matter will come up after that. Okay. Yes.
Item 2, part 2.
Yes. Mention is made on behalf of Mr. F. Lal Indiana, learned counsel for the appellant, for adjournment of the matter with the consent from the other side. In view of the above, list after 2 weeks.
Another quick mention, Your Lordship, item 1, part 2. Although it's fixed for 11/9, Your Lordship, as mentioned earlier, the leading counsel will not be able to come back soon.
Okay. Mention is made on behalf of Ms. Dinari Tel Azu, learned counsel for respondent number 2, for adjournment of the matter due to bereavement in the family. In view of the above. No, but you make mention on the 11th. It's listed for 11th. So on the 11th, when the matter comes up, okay, then the counsel from the opposite side will also be there. No need to pass any order. Yes.
Admission, item 2.
Yes. Finally, You are
My lord, I
Mr.
got confused. I'm really sorry.
No, that's okay.
My lord.
You're Mr. VK Shroff, is it?
Yes, my lord. I'm sorry, my lord. I thought that it is item 2 of this for list has been called.
So what is the
My
state?
lord, I am appealing. Lordship, I am appealing for respondent number 225 in this case, Lordship. Lordship, what has happened, my lord, we are supposed to file our affidavit by today. However, my lord, due to change of, my lord, the jurisdictional commissionerate of the petitioner, my lord, the entire thing has to be rerouted. And therefore, my lord, we are bringing further 2 weeks time to file our affidavit, Lordship, for respondent number 225, my lord. That is income tax authorities, Lordship.
2 to 5. What about
My
the
lord.
other respondents?
Lordship, I'm appearing on behalf of respondent number 1.
Okay. So all the respondents are represented. Have you filed your counter
Not
affidavit?
yet, my lord.
Okay. Mr. VK Shah, learned counsel for the petitioner, is present along with Mr. Yes,
I-
for respondents number 2 to 5.
225, I am S. Chetian,
S.
Senior
Sekia,
Standing Counsel, Income Tax Department.
learned standing counsel for respondents number 2 to 5.
Lord.
And Miss Baby so-and-so appearing on behalf of learned CGC, respondent number 1. Yes, state government, are you also
Sir,
party?
My lord, there is an interim order, my lord. Let it be, my lord. Continue.
So
my
make
lord.
it comma and Ms. Lalnundlui, learned government advocate for state respondents number 6. The learned counsels for the respondents have all prayed for time to file their counter affidavit. In view of the above, list the matter after 3 weeks.
My lord, kindly keep it on 9th of October, my lord.
Okay, after 3 weeks on 9/10/2025. Full stop. Meanwhile, the interim order passed earlier shall continue till the next date of listing. Yes.
But may I request, my lord, they have sought several adjournments for filing affidavit. Let it be the last opportunity, my lord.
We'll see in the next date what happens, okay, accordingly. Yes.
Grateful.
Deeply obliged.
Item 3.
Item 3, the land, we have stated that it belongs to the forest land. So I think they need to make the forest department a party in this case, madam.
So you were praying for time to see whether the landed property. You're appearing on which, behalf of which department?
My lord, for all the respondents now,
So all the respondents are, which departments?
PWD, Land Revenue and Settlement, and DC Long Plan. The forest department has not been made a party in this case. I think they are a necessary party in this one.
What is the case about? The petitioner, why have you filed the, this is a, okay. This is an NGO, Long Clyde District Landowner
Yes, sir.
Association, is
Yes,
it?
sir, Lordship.
So what is your grievance here?
We are praying for the you're praying for the landed property of the petitioners were acquired by the
Petitioners, but this is an association, not an individual. That's what I'm
Yes, Your
trying
Lordship,
to
the
understand.
petitioners. They were formed the landowners association.
Oh,
There are hundreds of petitioners, landowners.
so you're praying for compensation,
Yes,
but
Your
when
Lordship.
it's compensation, it will be individual persons, isn't it? Not an association.
Yes, Your Lordship.
There's
However,
also contempt here. There was some contempt connected with some contempt petitions, is it? There are two WPCs. Contempt case number 1 of 2020. What is this?
Contempt has been closed, madam.
It's closed now?
It's been closed. Earlier, an award was made, and there was a stay order not to maintain status quo. And after that, my lord, some modifications has been made in the award. That's why
Okay.
the contempt was filed.
So now the government says that the forest department also appears to be a necessary
Yes,
party. What do you say?
then
You have to
that-
see a case. I don't know what
Yes,
your
yes,
case
Your
is
Lordship.
about. Huh?
Recently the Union of India has filed their affidavit, additional affidavit. That stands for that the state government has to clarify whether it has been overlapped by the forest area, the forest land. So that has to be clarified by the state government.
So if it needs to be clarified, they're saying that the forest department also needs to be a party so that they can also be involved in the case, isn't it?
Then it, yes, Your
So,
Lordship.
so
Then
you
in that
file
case, I
an
have to
impeachment
implead it, yes,
application,
Lordship.
yes. Mm. Okay, heard Ms. Linda Elfamba. No, we'll make it Mr. K. Rowland, learned counsel for the petitioner is present. Heard Mr. K. Rowland, learned counsel for the petitioner, along with Mrs. Linda Elfamba, learned additional AG for the state respondents, and Ms. Baby so learned counsel appearing on behalf of Ms. Zairim Sangpui, learned CGC, for respondents number 8. Full stop. The learned additional AG submits that on the perusal of the case, it appears that the forest department is a necessary party in the instant writ petition. Full stop. Then Mr. K. Rowland, learned counsel for the petitioner, has prayed for time to file an pleadment application in pleading the forest department. Accordingly, list after 2 weeks.
Item 4.
Your Lordship, in this matter, this is the case in which the writ petitioner passed away. So we're in the process of filing the substitution application, Your Lordship. So I seek
Last
another-
court date also same pray.
Yes, Your Lordship. Because there's been some communication with the family of the.
Okay, we'll give you some more time.
Hello.
Heard Mr. Vandal Khaka, a learned counsel for the petitioner, who has prayed for further time to file a substitution application on the device of the petitioner, Mr. H. Lalthazawa. In view of the above, list after 2 weeks.
Obliged.
Item 5.
My Lord, this case pertains to the occupation of the petitioner land by the BNLF, Bru National Liberation Force, returnees under the instructions of the government. In fact, we had earlier approached this
Yes,
court
yes, huh.
directing the state respondent to conduct spot verification. And all the reports were made available along with this petition, my lord. And there was a little confusion regarding the, I may take your lordship to the page number 61. Page
Yes.
61. My lord, number 1, HB Tanzama. Whereas the petitioner number 1 did not find his name in the list. For this purpose, I required some clarification. My lord, I have found out that HB Tanzama was the father of petitioner number 1, Lalom Puyang. In fact, HB Tanzama died, and in his place, his son, as a legal heir, replaced him.
Okay,
So,
so
that-
Lalompuya is the person, so what happens? So there will be no confusion, is it?
No
later?
confusion at all, my lord. And my lord, apart from that, just one, I may take your lordship to page number 53. This is the minutes of the meeting under the chairmanship of the chief secretary regarding the payment of compensation in the compliance with the order passed by the High Court, Honorable High Court, at page 54, para 3. Page 54, para 3, with lordship permission. The meeting suggested that, subject to approval of the government, land of all the 8 petitioners and land of Pu Lairo Kuma. Lairo Kuma did not approach the court along with the other petitioners, may be purchased by way of negotiated purchase, that is for crops plus land value. The matter will be processed by General Administration Department for consideration of the government. After concurrence of the government, steps may be taken by LR&S, Land Revenue and Settlement Department, for negotiated purchase under the provisions of notification number so and so. My lord, in compliance with these minutes, page number 56, I may take your lordship to page number 56, that is the notification which I have read earlier in the last court date. Here, your lordship would like to
Just come back, what
there
is
is-
the notification,
right.
how?
My lord, I have a notification with me here. This notification will clarify the confusion, my lord, regarding the point made there in here. Notification, I'm reading, whereas the General Administration Department, Government of Mizoram, requires plot of land belonging to 8 petitioners and Pu Lairo Kuma in the WPC number so and so, Mamit for accommodation of Ru National Liberation Front returnees. Now, therefore, the government of Mizoram hereby grants concurrence to the proposal of direct purchase for all the required land by the State Department for compliance with judgment and order issued by the Guwahati High Court, Aizawl Bench. As this is in compliance with the High Court's orders and minutes of meeting dated 1/3/2021, held in the Chief Secretary's conference rooms, all the procedure of the terms of reference of the Departmental Land Selection and Purchase Board cannot be followed, and therefore, and hence, point number 4 to 9 of the TOR are hereby exempted. This TOR, my lord, will be found in the notification which I have just furnished to your lordship. 4 to 9 at page 2, my lord.
Okay, yes,
The requiring department will lordship permission.
yes.
The requiring department shall issue open advertisement of its requirement, specifying the purpose, preferred location, area, and other characteristics of land required on at least 2 local newspapers. This formally
Okay, not required because they're already occupying.
This notification exempted point number 4 to 9, my lord. This will clarify the instant notification, my lord.
Okay, then what about these WPCs, WPC 118, 170, 120? The petitioners here are the same as the
Are the same,
instant?
my lord.
Okay,
Are
so you
there-
have filed a fresh writ petition?
My lord. So on the basis of the instant meeting minutes as well as the notification, the instant petition can be disposed of with the direct. And my lord, one more thing. The meeting under the chairmanship of the chief secretary, they wanted inquiry into the matter with regards to the authenticity of the periodic patas held by the petitioners. And accordingly, this was clarified by the director as well as the, in fact, settlement officer, Land Revenue and Settlement Department, page 60. Page 60 is the clarification after conducting inquiry into the matter. All the periodic patas held by the petitioners are having government-approved number which have been indicated therein at
Yeah,
page 61, my lord.
61, isn't
This was
it?
done by the department officer in accordance with the order issued by the state government. So the same was done, and in compliance, accordingly, the present petition can be disposed of with a direction to the state respondent
Yes.
to make
Then,
payment, so and so on.
additional AG, you filed your counter. So what is your stand here?
My lord, we have some doubts regarding the genuineness of the passes. And we have enclosed our action taken report
Where,
at page 11 of my affidavit. Dear my
this
lord,
is dated when? Because there was another action
this,
taken when?
This is in 2020.
2020. And this clarification, page 61, isn't it? This was done when?
This is later, my lord, 2020.
22. So subsequent to year 2020, another clarification was made in 2022. So what do you have to say about the 2022? What you mentioned is in 2020, isn't it?
Yes. No, there's no other.
But you have not
steps
addressed
taken.
this to the latest one, 2022, which it is the same government approved. So after that, another step has been taken. This is issued by Settlement Officer, Mamit District. So I think we can
I
dispose of.
think we can dispose it of. However, I'd like to just make a point here that in the action taken report at page 11,
Page 11, yes.
brief chronology of events at the bottom. This is with regard to the present petitioners. Judgment and order in WPC 118 of 2013 dated so and so. Court had remanded back the matter to DC Mamit District to verify the lands of the petitioners, as the court found it difficult to give appropriate direction and to entertain claims of compensation if entitled. It was also observed, noted by the court, that the government approval of the periodic pata was given as early as 2005, 15/5/2005, though the said periodic pata was issued only in the year 2009. Further, from perusal of the field verification form annexed to the affidavit in reply filed by the petitioners, it was revealed that such verification was done way back on 19/4/2001, and that approval of the periodic pata was conveyed by the government as early as 2005. So,
Old. But that's why there's this latest 2022. Now, what is the
there's no
2022?
other fresh steps other than.
Fresh steps after that is this. So here it says, let's see, what do they say? Reports, government approval, wide order 2005, pass number so and so, that's all. When they say pass number, it is what? Periodic pass.
Yes, my lord, periodic patas. All of them.
But periodic pass, is it renewed? Periodic pass has to be renewed after. So is it renewed up to date, whatever, that you have to see?
My lord.
So we can dispose of by pursuing this
latest report.
latest 2022, and whether based on your periodic pass you entitled.
My lord.
Isn't it? I'll pass the order accordingly.
My lord.
Disposed of. So the state government will have to take further verification based on this report dated 2022. Isn't it?
Yes, my lord. One more thing, my lord. The matter has been pending for the past more than 10 years.
So within how long will you take? Verification, Mohammed,
2 months.
within 3
This
weeks?
verification, my lord, already it was done by the Mamit.
Huh.
It was
So
furnished by the
verification
Mamit.
was done, Mohammed DC. So the date, now they're saying that these are old verification and the pass is 2009, whatever. So based on this pass, periodic pass, whether a compensation is to be paid, and if so, to be paid expeditiously, within
1 month.
within 1 month, okay, from the date of certified copy of this order.
Right.
I'll pass the order accordingly. Yes.
Obliged.
Item 6
Allowed
is-
and disposed.
One of these cases has been fixed for admission hearing today.
Your Lordship, I'm appearing on behalf of the state respondent. This matter was previously handled by Mrs. Carolyn, and although this was fixed for admission hearing, Your Lordship, if I may be given at least 2 weeks' time. It can be listed for admission hearing on the 23rd of September.
CGC, last chance was given to you to file your affidavit
We
opposition.
will not be filing affidavit.
You'll be filing?
We
You'll
will
not be filing?
Yes, madam.
Okay. What is the matter about?
This is a case relating to National Highway 302. We are the tenant of the landholders whose land has been acquired. Now it relates to second schedule of the Right to Fair Compensation Act. We have to be paid rehabilitation.
So why aren't they paying? What is their stand? If land is acquired, you have to pay, then why isn't the compensation being paid? What is the problem? Yes, government, you don't know.
So they have,
We have filed-
they have distinguished between landowners and their tenants.
Okay. In your counter, you're saying that they are not landowners. Or what? What is your case? Anyways, we'll give her some time then. It was previously handed by?
Mrs. Carolyn, Your Lordship.
Okay.
Carolyn Killen. 23rd, if the matter may be fixed on the 23rd, Your Lordship.
Okay, heard Mr. Silal Pagzola, learned counsel for the petitioner. Full stop. Also heard Ms. London Louis, learned government advocate for the state respondents, who submits that since this matter is being handled by Ms. Caroline K. Lalumwapi, learned government advocate who is on leave, she may be given time to study the instant matter. Caroline K. Lalumwapi, who is on leave. Okay. And therefore, she may be given time to study the matter. Full stop. Then, yes, what do you have to say in this matter? What is your case? Not to pay what? Who is the person who has to pay the compensation? If compensation is to be paid to the petitioners at all, who is the person? From whose pocket? Okay, that's been disputed.
No, my lord, as per the act,
No.
it's the competent authority that which is the central government.
Okay.
We
Central
are-
government is not filing the counter. That's what I'm saying. Central government is not filing the counter.
Because, my lord, NHI DCL being a project implementing only, my lord, we do not have the authority.
Okay.
Yes, madam.
But then that's why central government, if you're not filing a counter, then you're agreeing to this, isn't it? Then the plea of the petitioners can be granted. Is it?
not disputing what we have said.
If you're not filing a counter, but why aren't you filing a counter?
Lordship, we already sent a reminder, but till date, we did not receive any instruction from the concerned authority.
Anyway, so in your counter, the NHIDCL, you're saying that we are not the persons responsible to pay the estate amount. Is it? That's your stand?
Yes, my lord, because.
And,
yes,
but whatever claim made by the petitioners, you agree to it? Is it? No, I'm just curious.
yes, my lord.
Because the money is to be paid by the Union of India, so they are the ones, if they are aggrieved by the claim of the petitioners, aren't they the ones who are to file the counter? Since you're saying you're not going to file, I'm just curious. I haven't really gone through the facts of the case. No? Anyways, what about the state government? What is your stand?
Your Lordship,
Or you still don't know, you have to
Your
study the
Lordship,
matter, huh?
Yes, Your Lordship, but as per the submissions made in paragraph number 9, if I may read, Your Lordship, it says that the land acquisition is directly done by MORTH, Government of India, through its appointed functional officers, that is the competent authority, so and so. All the examinations, approval, and payment of compensation of rehabilitation and resettlement is to be done by MORTH through NHIDCL, and hence the state is not in a position to settle the claims of the petitioners.
So government is also washing off their hands, NHIDCL is also washing their hands and saying it's the union. But union is saying they're not filed their counter. Then the case of the petitioner has to be allowed, isn't it? That's what I'm just asking. Anyways, we'll fix another date. Come see. Then we'll have to hear the petitioner and the other respondents. But the Union of India, you have no say in this matter. Then what to do? Have you contacted the Union of India?
We sent them reminders so many times.
Okay. When was this writ petition filed? 24? Oh. Anyways, we'll see in the next date. No, because I've noticed in the last court date we had given you a last chance. But if the matter is really pertinent that you have to file, then the court can still accept, okay, an opening, because you have to make sure that justice is done for both sides. But since you say you're not filing, then it becomes a little bit difficult. Anyways, we'll fix another date. Also heard Miss Lalun Louis, isn't it? I don't know who was put some. In view of the above, list after 2 weeks. Miss Baby so-and-so appearing on behalf of Ms. Zaram Sangpui, learned CGC, submits that they will not be filing their counter affidavit, while Mr. Samuel L. Sangte, learned standing counsel for NHIDCL, submits that they have already filed their counter affidavit. Okay, the list after.
My lord, may we have a fixed date?
2 weeks on
23rd.
23rd, 9. Is it 2025?
Obligation.
Item 7.
My lord, I have found from the records, notice upon the sole respondent came back unserved.
Oh,
So
then
I may
correct
be
address.
permitted to do the personal service. That's the
Okay,
service.
that's the,
my
okay.
lord.
Heard Mr. L.H. Leon Shima, learned senior counsel for the appellant, assisted by Miss Sarah so-and-so, learned counsel. Lalwat Kali, huh. The learned senior counsel submits that since the office note dated 04/08/2025 indicates that notice could not be served upon the sole respondent being not found in the given address, he may be allowed to serve notice upon the sole respondent through dusty mode. So, accordingly, the learned senior counsel for the appellant is to take steps for service of notice upon the sole respondent through dusty mode, and affidavit to that effect is to be filed accordingly. List after 3 weeks.
3 weeks, my lord. And my lord, Status quo as per dated 4/7/2025 be continued.
Meanwhile, a status quo in the case is to be continued as per this court's order dated
4/7/25.
04/07/2025. Yes.
Obliged.
Item 8.
Yes.
My lord, the matter was settled on 2nd September through mediation.
Okay, respondent number 2. What did you say? Mediation could not settle.
Yes, my lord.
Then what is the
Your
state?
lordship, it is settled through mediation.
Okay, settled.
Yes, settled, my
Oh,
lord.
okay. So, what is the term of settlement? Let's see. How have you settled? Your pension, you had claimed for pension, is it?
Yes, my lord.
So, the director will examine the application and determine whether you are entitled to pension. Very good, very simple, isn't it? So you are not really saying that you have to receive the pension. They are going to see whether you are entitled as per the pension rules. You happy with that?
Yes, my lord, because earlier Transport Department object our application because of that.
But supposing they object again, saying that you are not entitled as per the pension rules.
Now the Transport Department allowed to process our application.
Okay.
And the same should be forwarded to the Accounts and Treasury, and they will examine
Okay, the
our
matter.
application.
Okay.
Yeah.
So it's going ahead. Instead of being blocked at the Transport Department, they are going to forward.
Yes, my lord.
Okay. I'll pass the order accordingly. Okay, in terms of the agreement, we'll pass a compromise degree.
Much obliged, lord.
Orders, item 9.
May I please, your lordship?
Yes.
Your lordship, a bail application has been filed in connection with the session registration case number 278/2023 under section 21C of NDNPS Act. Your lordship, I'm here for the accused I'm here for the accused Abdul Kalam Loscar. Your lordship, mainly I have filed the bail application based on the parity grounds.
My lord, I have come across this petition for the first time. If it can be taken about.
Let her finish. Yes.
May I, your lordship?
Yes.
Your lordship, mainly this petition has been filed on the parity ground as the main accused from whose possession of the drugs were recovered got the bail from the Honorable Guwahati High Court on 14 July 2025. Similarly, the other accused, co-accused, the driver of this truck, with whom I was traveling on that particular night of the 11th June 2023 as a handyman, got the bail from the Honorable Court on 11 July 2025. And similarly, based on the parity ground, the co-accused Kutbul Alam Loscar also got the bail from the Honorable Guwahati High Court on 29th of July 2025. Similarly, based on the parity ground, your lordship, I have filed this petition, and I pray since the accused was arrested on 11 June 2023. After
Yes, good
that,
enough. So will issue notice, isn't it?
obliged to your lordship, but your lordship, I pray for a short date as both the co-accused are already on the bail, and moreover, your lordship, there were 14 prosecution witnesses, out of which 9 were already examined, and the accused is being languishing in judicial custody for more than 2 years, 2 months, and 29 days as of now. So, your lordship is behind the bar, like before getting the actual judgment, is for a prolonged period.
Heard, Miss? Your good
Lubna
name, please?
Chaudhary, your lordship.
So-and-so, learned counsel for the petitioner who has filed the instant bail application under section 483 of BNSS, read with, what read with? 37?
Yes, Your Lordship.
of the NDNPS Act for the release of the petitioner on bail. Stop. The Learned Counsel submits that the petitioner was arrested on 11/06/2023 for the alleged commission of an offence under section 21 within brackets small c of the NDNPS Act on the seizure of how many grams? 5.810, is it? Kgs of heroin. And
Yes, Your Lordship.
criminal trial number 1381/2023 was registered against him. Full stop. The Learned Counsel submits that the petitioner has been in incarceration since for almost 2 years, is it?
2 years, 2 months, 29
Okay,
days, Your
2
Lordship.
years, 2 months, 29 days, while the co-accused persons, they have been granted bail, have been released on bail. Full stop. Issue notice to the state respondents, Mrs. Linda L. Pombal, Learned PP accepts notice on behalf of the state respondent. List the matter after, yes, list the matter in the next week. Okay. In the meantime, requisite copies of the bail application to be duly furnished to the Learned PP. Yes. Give the copy.
Your Lordship, next week, which date, Your Lordship? Because I will be appearing personally there.
So which date do you want? On?
Your Lordship, next Monday.
Okay, on Monday,
That will
next
be on
week, on Monday.
next
Okay,
Monday.
give Monday's date.
Highly obliged, Your Lordship.
Item 10.
Your
Yes.
Lordship, it appears that TCR is received. Paper book will be required for disposal of this appeal, my lord. And in the meantime, regarding IAM, my lord, while preparation of paper book, I may be allowed to file written objection regarding IA. IA is for
Who's the distinct counsel for the appellant?
uh,
Samuel L. Ampui.
yes, the leading counsel is from outside.
Okay, anyways, none appeared for the appellant while Mr. B. Ramena, Learned counsel for the
Respondents,
sole respondents or one?
all the respondents.
For the respondents is present and submits that TCR has arrived and prayed that paper book may be prepared. Accordingly, paper book is to be prepared at the expense of the appellants. Meanwhile, the Learned Counsel for the respondents is allowed to file his written objection, if any, in the connected IA civil number 84 of 2025.
Much obliged.
Item 11.
Witness, Your Lordship.
Yes.
This is the bail petition under section 483 of the BNSS, read with section 37 of the NDNPS Act, my lord. So the brief facts of the case which led to filing of this instant petition is that, my lord. So on 6th of July 2024, 226 bottles of cough syrup was seized from the residence of the present petitioner. And then in connection with the seizure of the cough syrup, she was arrested and she is being detained in custody till that, my lord. So, my lords, I am raising only one grounds, that is the grounds of arrest, my lord. So, my
Okay.
lord, yes. My lord, if I may kindly take your lordship to page number 16, that is the seizure and arrest memo, my lord. So, my lords, my grounds are founded on this seizure and arrest memo, my lords. If I
What's
may
wrong
read,
with
my lord.
this?
Seizure and arrest memo. I, Arlardin Sang, a sub-inspector of excise and narcotics, do hereby seize the undermentioned articles on this day, 6 July 2024 at 5:25 p.m. at Singaveng, Section C, which was recovered from inside the residence of the accused. I also arrested the undermentioned accused for possessing the seized articles at the same date, time, and place in presence of reliable civilian witnesses. The intimation of this seizure and arrest was given to her husband at the spot. Seized articles 226 vials of cough syrup containing codeine phosphate, 22.600 kg, branded cough trip. Arrested person Malsom Kimi, wife of so-and-so, resident of so-and-so. So at the bottom of my page, at the bottom of the page, my lord, that received and countersigned by the accused, Malsom Kimi, my lord. So my lord, my first contention, my humble submission is that, my lord, on perusal of this seizure and arrest memo, my lord, the grounds of arrest, which is the basic facts and circumstances, like the particular of offenses, why what she has committed, and why she is being arrested has not been provided in this seizure and arrest memo, my lords. So my lords, the very purpose, the hard purpose of the grounds of arrest is to provide the detainee to contest and challenge the remand order, and to be defended by a lawyer and to seek bail. My lords, if the offense he has committed has not been conveyed to the accused persons, my lord, how can she, in my humble opinion, my lords, how can she challenge the remand order?
She's charged under what section?
Under section 22C, my lords. So that is my first ground, my lords. So, my lords, as per Article 21 of the Constitution of India, my lords, no person shall be deprived of his life or liberty except the procedure established by law, my lords. My lords,
So
the
one or two authorities?
My lords, the procedure has been...
So the apex court has also
Yes.
made mention. So give me one or two authorities. Don't look into the law.
Yes, my lords.
Anyway, sir, what do you want to say? What do you
My
want to
lords,
submit?
that the procedure established by law as per Article 21 has been incorporated in section 47 of the BNSS, my lord.
Grounds of arrest, isn't it?
And particulars of the offense, my lords.
Anyways, so give me one or two authorities of the
Yes.
apex court.
Okay, my lords.
The latest will suffice. Or two. So you're saying the section of law has not been mentioned, only the seized article, what has been seized.
My lords, that is Vihan Kumar.
So section of law has to be mentioned or what? What has been seized? You know why you have been arrested? You have been arrested because of so many what bottles of this thing was found, isn't it?
My lords, that the from paragraph 19, my lords.
Of which one?
Vihan Kumar, my lords. Vihan Kumar, 2025,
Yes,
volume 3,
yes,
Supreme.
yes. Para?
Para 19, my lord. If I may read, my lord.
Okay, whatever, 19.
An argument was sought to be canvassed that in view of subsection 1 of section 50 of the CRPC, there is an option to communicate to the person arrested full particulars of the offense for which he is arrested or the other grounds for the arrest. Section 50 cannot have the effect of diluting the requirement of section 22, article 22, clause 1. If held so, section 50 will attract the vice of unconstitutionality. Section 50 lays down the requirement of communicating the full particulars of the offense for which a person is arrested to him. The other grounds for such arrests referred in section 51 have nothing to do with the grounds of arrest referred to in article 22, clause 1. The requirement of section 50 is in addition to what is provided in article 22, clause 1. Section 47 of the BNSS is the corresponding provision. Therefore, what we have held about section 50 will apply to section 47 of the BNSS. My lords, in addition to article 22, clause 1, the full particulars of the offense as per section 47 has to be provided to the detainee, my lords.
Okay, I got your point. Yes.
So, my lords, that my next submission is that, my lords, so on perusal of the arrest memo, it is written in English, my lords. There is nothing on record that even in the charge sheet, so that the detainee, the accused, had fully understand the English language, my lords.
So how do you know that she doesn't understand English?
So, my lords,
She may be
I don't have
understanding
any knowledge
also.
that, my lords,
Ah,
that the prosecution,
so we'll presume that she understands, unless, isn't it? In the language, she must be knowing English. Unless she's so illiterate, but you have to show that she's illiterate, she's only a class 1 student or something. If you don't have that, we'll presume she knows English. Then what else?
my lords,
That's all.
yes,
isn't
my
it?
lords. That, my lords, in Vihan Kumar, my lords, that paragraph 21, also, my lords. I will not read out, my lords.
What is 21?
The conclusion are there, my lords. So, the requirement of informing a person arrested grounds of arrest is mandatory, and then the knowledge of the basic facts constituting the grounds has to be imparted and communicated to Harmony.
Okay. But here you have section 37 also, isn't it? This is a different. Yes. That's it.
My lords, I have another citation, a coordinate bench order, my lords. That is the bail application number 1229.
Coordinate bench of this court.
Yes, my lords. My lords, paragraph 27, my lords. In the instant case also, as discussed above, it is seen that there is no mention of grounds of arrest in the arrest memo as well as in the notice issued to the present accused petitioner under section 50 of the CRPC. And except the name, address, and the case numbers, there is no mention about any other particulars of the offense as well as the grounds of arrest. So from the proviso of section 50 of the CRPC, it is seen that there is clear violation of mandate of Article 22(1) of the Constitution of India. And in such cases, in spite of statutory restrictions under Section 37 of the NDPS Act, this court is of the considered opinion that for the violation of the Constitution mandate contained under Article 22(1) of the Constitution of India, the arrest of the petitioner is vitiated and it may be a sufficient ground to consider his bail application in spite of rigor of Section 37 of the NDPS Act, which provides the restriction in granting bail in the case of commercial quantity under the NDPS Act. My lord, on perusal of the arrest memo, name, place has been only mentioned, but my lord, the particulars has not been mentioned, my lords.
The section of law has not been
my lords.
mentioned. Otherwise, what was seized, everything is known to you. Anyways,
This
where?
aspect has already been considered. This
Where?
aspect has already been considered.
Fresh ground not given when fresh ground not given when we have not mentioned that in your bail. We have not mentioned that in your bail application. Where they have approached the application. Where they have approached the High Court. High Court. They approach the district court. They approach the district court or the High Court.
No, my lord, the district court.
That's the only issue out here. She has been arrested because of this, that's clear. But the section,
Only the section is mentioned, not mentioned, my lord. So I don't think any prejudice is caused because the seized articles has been clearly mentioned in this case.
okay.
My
Yes.
lords, may I have only one submission to reply my learned. So, my lords, the present petitioner is having a drugstore under the drug license issued by the competent authority, my lords. So, if there is any violation on her part, according to the license granted, so there can be an offense under the Drug and Cosmetic Act or the NDNPS Act, my lords. So he is still confusing, my lords. So what kind of offense he has committed has not been mentioned, my lords. Not been mentioned, my lords.
Okay. Drugs or cosmetics or NDPS, he doesn't know. Is it? Automatically, if it was heroin, maybe he knew that it would be NDNPS. But here he's saying drugs and cosmetics also could be charged. Anything to say regarding that? Okay, I'll just consider your submissions.
Highly obliged.
Item 12.
Yes.
Lordship, I am now awaiting instruction, my lord, for filing objection. So if I may kindly be granted, my lord, 1 week's time for that, my lord.
How many times have you approached this court?
My lord, this is the second time.
Second time. Previously, it was not granted, is it? Why?
Yes, my lord.
Why was it not granted?
My lord, it's at page 28A.
So now we have approached the court again for whatever reason here. So some fresh grounds have arisen or what?
Yes, my lord. There are some medical grounds as well.
This time medical?
Yes, my lord. And some technical grounds as well.
Because you can't come again and again to the court unless there is some new development, isn't it? So now you have approached the court again because of some medical grounds. Medical grounds, you have the medical documents enclosed?